You know, last lecture we have left exactly the very decision of the USA Supreme Court in that particular leading case, that is US Airways Inc. versus McCutcheon in 2013. So the Supreme Court in this case rules why the majority 5-4 that the planned language at issue was silent in negating the common fund doctrine of whether the plan should bear any of McCutcheon's attorney's fees and litigation cost incurred in obtaining the recovery. The court stated that the common fund doctrine could be read into the language and remanded the matter back to the district court to determine how much the plan's reimbursement should be reduced for attorney's fees. And the very principles held as such extension of outcome of the principles of indemnity, and also regarding the common law of subrogation applies to all the contract of indemnity arises only after the payment of claim is made to the insured by the insurer. So the principle of subrogation provides insured to provide all necessary assistance. The insured is required to provide all necessary assistance to the insurer, except in the case of marine insurance policy or against the rights of subrogation against the defaulter party. So also the principle of subrogation, the insurer is granted the right to sue the third party at default in his insured's name, but the expenses of litigation are to be borne by the insured, and also it arises from the acts of torts, contracts, and as such the rights of subrogation arises from the acts of torts and contracts. And now finally we'll discuss the very principle, and that is the principle of contribution. So, in regards to that, we would like to discuss what exactly the very principle of contribution means. So, contribution exactly where a particular property is insured with two or more insurers against the same risk. It is called double insurance. In the event of loss, the insured will get the compensation only for the amount of actual loss. He will be compensated by the concerned companies on the basis of principle of contribution. The insurers must share the burden of payment in proportion to the amount assured by each. Thus, if in such a case the whole loss had been paid by any one of the insurers, is entitled to contribution from the other insurers. This is called as the right of contribution. of the insurers and is available only in case of double insurance. Notice that it is necessary that the different insurers and is available to insure the same interest in respect of the same property and the same peril. So, exactly in this case of the principle of contribution, as we want to discuss the very rules of contribution, and in that connection, would like to discuss that the policies must all cover the same property and the same event, and all the policies must be in effect and enforceable conditions have been met, and a cover property, the contribution principle will go into effect for the involved and the companies. So, yeah, exactly, we found the very important leading case, that is Goodyear, Canada Inc. vs. American International Cas Company in 2013, the Court of Appeal. Yeah, the Goodyear faced claims for selling asbestos-related products from 1968 onwards. Goodyear had liability insurance from 1968 through to 1980. However, from 1980 to 85, Goodyear elected to self-insure. Starting in 1985, coverage for asbestos risks became unavailable in the market as insurers ceased to underwrite the risk. On motion to the Ontario Superior Court of Justice, Goodyear set to compel its 1968 to 1980 insurers to cover the post 1985 liabilities. But Justice Stone rejected Goodyear's argument and his decision was upheld. So the Ontario Court of Appeal cited four reasons for rejecting the very principle under which the argument was based, that was the principle of the name as Stonewall principle. By rejecting the Stonewall principle, Justice Stone rejected Goodyear's argument, and he cited four important reasons rejecting the very principles developed by Stonewall, and the very reasons he cited are: it is inconsistent with the language of the pre-1980 policies, which only covered damage occurring during the policy period. And the Stonewall principle was not seen as highly suspect by many USA courts. And the third reason of rejecting this Stonewall principle by Justice Stinson was that Ontario policy consideration militated against its adoption. And the fourth reason cited by Justice Stinson rejecting the Stonewall principle was that the law of Ontario historically applied the pro data allocation method, which was inconsistent with the Stonewall principle. So Goodyear chose to continue manufacturing asbestos products knowing that insurance was longer, no longer available and as such should be held to its business decision to the court's risks. And also in that connection, we would like to discuss another important leading case, that is Bodwin versus Wah Nisha Mutual Insurance Company, which was also decided in 2013. So, in that particular case, the court held that in their finding that the exclusion did not apply. So the Court of Appeal focused on the differences between the language in the coverage grant and that of the exclusion. The policy covered bodily injury or property damage arising out of your personal activities anywhere in the world, while the narrower exclusionary language excluded coverage for bodily injury to you or to any person residing in your household. The Court of Appeal in this important leading case held that the claim was not one for the injuries to the debtor, but instead was one for contribution and indemnity arising out of negligent supervision. So the very contribution principles rules develop that before the contribution principle kicks in for insurance companies, a double insurance situation has to meet certain requirements. The policies must all cover the same property and the same event, and all the policies must be in effect and enforceable conditions have been met and cover property. The contribution principle will go into effect for the involved and companies. So, these are the general principles that we found under an insurance contract. So, for the very validity of insurance contract, in particular, to marine and fire insurance contract, the first principle contract of indemnity is applied. So also, the fourth general principle, causa proxima, and also mitigation of loss, and also the principle, that is the principle of subrogation and principle of contribution and mitigation of loss or minimization of loss are applied, and as such regarding the very principle of contract of indemnity, which is not exactly applicable to life insurances also. Yeah, in regard to insurance contracts, all these eight general principles that we have discussed, as a contract of indemnity and utmost good faith and insurable interest and the principle of cause of proxima and mitigation of loss and the risks must be attached. So also the principle of subrogation and principle of contribution. So exactly almost all these principles are above all are applicable to marine and fire insurance except the principle of utmost good faith, insurable interest as such would be applicable to all the insurance relating to life insurance. So, in this lecture, we have completed our remaining portion in regards to the very principles of involving law of insurance or insurance contract.